want to tell you from my own experience and take a step back and tell you about the structural reforms of the branch in the last 15 years that not only made the branch a strong institution, but also overlooked is the fact that without the branch infrastructure as it exists today, created 15 years ago, I tell you I would not have the opportunity to stand in front of you as Chief Justice of California. So let me step back and tell you that 3 years ago, when Chief Justice Ronald George, a great man, he gave the lecture here, the inaugural lecture for the series named after him. I know for certain that he talked about the 3 major reforms in California that always bear repeating, because like Lady Gaga, we were not born this way. And so the 3 that he talks about are first, in 1997, the statewide funding of the trial courts, because it used to be that the courts were funded by the counties. And as a result of county funding and 58 counties and 58 different relationships with their courts, there was disparate funding amongst the counties. And so citizens, people who lived in California who sought access to the courts, had an unequal treatment depending on the county in which they lived. So in 1997, under Chief Justice Ronald George, state funding became the basis and foundation for the trial courts. It brought to us stability of funding so that we could plan. The next major reform in the branch was in 1998, a year later, which involved the unification of the municipal courts and the superior courts. We went from a loose confederation of over 220 courts in California into 58 superior courts. We took 2 different offices in every county, the Muni office and the Superior Court office. We collapsed them into one for greater efficiencies, greater use of money, more direct and reasonable common sense service to the public. And so with that came strength in numbers in unifying from 220 into 58. And what I consider the 3rd largest reform in the last 15 years was when we became, as a judicial branch, responsible for the repair, modification, and construction of our courthouses. Now you might ask yourself how it is that those 3 structural reforms that strengthened the institution, that made us a co-equal branch of government, that gave us the ability to withstand these savage budget cuts in the last 3 years, how and in what way could that possibly have served diversity? And I tell you this, and that is, when the structure came together, there was a dawning recognition that amongst the 58 trial courts and the 6 courts of appeal and the Supreme Court and the Judicial Council, that we are in fact an incredibly diverse state. And we bring together cultures and people and practices that need some sorting out for some statewide rules. And so this infrastructure brought to the branch a forum for diverse voices, a forum to seek out people who had and represented these different interests, who had different experiences, to come together to distribute their best practices, to form policy for the state. And I was luckily one of those people who volunteered to serve on the state advisory committees. We have over 22 advisory committees. Many of you serve on them. Many of you are subject matter experts on these. You volunteer your time to make better rules and policy for California, the judicial branch, ultimately for the public. And what that really created was a huge table, a table where I could sit next to my brethren from Inyo County and put a face on a challenge in Inyo County, where they could see the face of Sacramento County and know what we bring to the table and know the makeup of our branch. It also permitted a forum where voices like mine could be heard, coming out of people that looked like me. We created bonds amongst each other. We solved problems with each other. We moved forward. What we did is we ended up creating a community of volunteers, diverse as the population we serve in the courts that we toil. And so when I think of the structural reforms that the great Chief Justice Ron George brought about, and mind you, they were reforms that had been in the works for the last 10 years by different chiefs and different governors and many legislators and many judicial council members, when Chief Justice Ronald George was able to masterfully bring those together and accomplish them, he also created an incredible road of diversity. He created a road where many of us could put ourselves on it, be part of the problem solving, and in helping others, unbelievably help ourselves. If I had not had the opportunity under that infrastructure to sit at the table and try to solve problems, I submit to you that I likely would not have had the opportunity to be Chief Justice of this great state. And now, as earlier mentioned, I think our structural reforms are under attack by two different entities. One is the budget, which we all face. To give you a snapshot picture of California's judicial branch budget, since 2009, we've been cut 30%. We've been cut $650 million while our caseload grows, while we haven't been funded for growth. In times when people are losing jobs, homes, services, and privileges, courts need to be open. But we're expected to do more, if not the same, with less. So what that means, as you all know, is judges are working overtime and harder. Staff is working harder and harder to do the work of folks who have been furloughed or laid off, to operationalize cuts. And so we are trying to do as much, if not more, with less. We are doing our part because we recognize that as a judicial branch of government, we owe a responsibility to be fiscally responsible. At the same time, however, we've also been, surprisingly, $1.1 billion worth of solution to the general fund. This year alone, the judicial branch, we've been accused of a number of things, but what people do not say is that the legislature took from us $350 million in construction funds to repair our courts. That came from you attorneys and your filing fees in our courts. They took a $350 million involuntary, no-interest loan. Also, a $90 million loan after that, and then ultimately, in the last days of the budget, swept $310 million. In addition, they cut us $350 million. And when I meet with the governor, I know, and he says to me, you have no leverage. It's because judges don't bring votes. Judges don't bring campaign contributions. What we bring is an adherence to the rule of law. What we bring is a promise of equal access under law. And these days, it's hard to sell that when people are losing health benefits and rights because we can no longer fund those. And so I recognize many of you in the audience with the help from the State Bar. We're moving forward with a coalition of attorneys to bring to the legislature the message that you cannot continue to cut the judicial branch budget without jeopardizing civil rights, and closing courts jeopardizes the public's access to their civil rights. So one area of attack has been the budget, but we have a solution to that based on the fine work of you attorneys and judges out there. But another area of attack, I tell you, is that against judicial branch governance, judicial branch structure. There are those out there and in the legislature who view the judicial branch as needing radical change, and people who would pass legislation overnight to change decades of hard work and decision-making by 4 governors, 4 chiefs, multiple legislatures, multiple judges and lawyers who volunteered to create not only the structural reform, but the structural reform that permits diversity in the branch. And what I fear from these attacks on judicial branch governance and structure is that they will destabilize and stifle diversity. I also fear that they will take away the rungs of the ladder that I climbed, that were provided to me, so that I could climb into state problem solving and into state advisory committees, into state solution, to one day be and have an opportunity to lead this great state of California. And so I tell those who think about trifling with judicial branch structure and governance that be careful where you tread, because it was really 25 years ago when Chief Justice Malcolm Lucas, following through on a promise by Chief Justice Rose Bird, created a special committee to study gender bias in the courts. And 5 years after that, Chief Justice Malcolm Lucas created the advisory committee to study racial and ethnic bias in the courts. And it's 5 years after that that Judicial Council adopted as its #1 goal, access, fairness, and diversity in the state. And so if you think that those kinds of reforms would have happened inevitably, I would like to beg to differ. Because progress not only in diversity, not only in human rights, not only in women's rights and poverty rights, is the result of deliberate, sustained effort by many trailblazers who are here tonight who started it. And I think that before we trifle with that, we need to tread carefully and look back at our history and see where we've come and yet where we still need to go. So it is against this background that I joined this impressive panel to talk about a subject matter dear to my heart and to spend this wonderful evening with all of you. Thank you, Dean Ramey.